I'm here today with Mark Hales from Jolly and Jolly, and we're going to discuss just a typical overall feeling that a lot of people in Utah think that there is a bias or a treatment towards men that's maybe not as fair as it should be. We know that your firm advertises that you're advocates for fathers' rights, which is a great thing, and I just wanted to talk to you a little bit about that, what your thoughts were on do you feel there is a bias, what the reasons might be for that bias, et cetera, et cetera.
So the first question, do I feel there's a bias towards mothers, you say? Actually, I don't really anymore in a lot of aspects of the law. I think for a time the law is set up that the primary caretaker was to get the kids.
Right.
And the Utah culture presumed that was women.
Right.
But when the father is the one that has been the primary caretaker or is the children living in the home, the court tends to favor the father and award them custody. So it's a factual thing more than a gender thing.
Okay.
So many of the factors the court would look at as to who should be awarded custody did tend to favor the woman for whatever reasons that the family established themselves.
If the mother is the stay-at-home parent and the dad is the one that has the income, etc.
Those, because of the factors the court uses, those favored the woman.
Right.
But I've seen in the past several years that the courts have recognized that children do need more time with both parents.
Okay.
And so they established the new code, Utah Code 30-3-35.1, which allows the non-custodial parents more overnights to be joint custody if they've been actively involved in the child's life.
And so you're referring to, that's the one where some people, I think I've referred to that part of the code as the fat weekend.
Yeah.
Where you get a little more time.
I always called it the extended minimum.
Okay.
It's the same minimum time, but instead of bringing the child back in the evening, it's always an overnight.
You get that weekend, a little more time.
Right. And I know there's been laws in the past that wanted the presumption of 50-50. And that can be great. I think a presumption that children need both parents is good, but at the same time, we don't want to, one parent disappears for years on end, or they travel a ton and they're gone 90% of the time. They can't be awarded joint custody. So I think there's more judges and commissioners that are awarding a joint custody schedule from the beginning. But we're not to a point where it's automatically presumed to be 50-50.
Right, and being a legal assistant, obviously my opinion of that before I started being a legal assistant was that, you know, there was more of a bias that just because, you know, one gender had the children more at home, I didn't really understand the dynamics as much as I do now, that, you know, if there's a huge amount of travel between, then it's just not realistically possible to be driving kids around and taking them to school at like 4 a.m. because you have a 2-hour drive. And so those are some of the things that are important and that make sense. It's that I wouldn't chalk that up to a bias. I would chalk that up to that's realistic. You can't be driving a kid 3 hours both ways and get them to school on time and have them going to bed at a normal time. Those are things that are going to affect the kids.
Yeah, I agree. I mean, distance is a huge factor.
Right.
I tell my clients all the time, try to live within a reasonable distance. Right. The biggest issue is, can you get the kids to school? Now, I've seen the court recently, as of this week or last week, order a schedule that allowed that fat weekends and the 35.1 when one parent lived in Ogden and one parent was in Sandy, Draper.
Okay.
They said if you miss school, that's over.
Right.
And that goes for both parents. And that was a case where dad was having the child for a year and was awarded custody because he had the child for a year. Now they look at a bunch of other factors, abuse and drugs and violence and work schedules to decide where the child should live. So simply keeping the child from the onset doesn't always work, but they don't really want to disrupt the
current living,
the status quo, the horse cart, or whatever the phrase is, on at least temporary orders. I think that's where a lot of the problems, a lot of guys get frustrated with. their wife or girlfriends takes a child. It takes a while for them to get to court. The commissioner doesn't want to disrupt the status quo for the most part. Says, I think joint custody is going to work, but I don't want to disrupt it now. The
Sure.
distant issues,
They don't want to interrupt the kids' schooling,
different
friends that
factors,
the kids have, etc.
all those things that may be this current status quo, which is understandable. I understand exactly why they're doing that.
Mhm.
But they think, okay, I think eventually at trial you should be able to be awarded joint custody.
Mhm.
But these guys don't have a lot of time and money to invest in a whole litigation, and therefore they give up or they call the system bad when it's not. They're just trying. They don't understand the limitations of temporary orders, and then they just say, "Oh, this system's bad."
Right.
Or I have clients coming into my office and saying, "Hey, the system's biased," and I'm like, "Well, what happened? Did you settle in mediation?" Well, yeah. If you're upset, why did you why did you give her custody if you
Buyer's remorse sort of thing.
Yeah, it's
Right.
like, well, I don't know. It's like if you agree to it, that's on you.
Right, you're
The
stuck.
court didn't do anything wrong.
Right.
I mean, there are judges out there that may be biased.
Right.
There are judges that do not ever agree to a 50-50 parenting schedule. Even if the parties agree to it,
Right.
they'll reject it because they don't think it works.
Well, if there's a legitimate reason to say, I know that for years, mom has had custody, etc., but situations and circumstances have changed with, for example, let's say I was always gone, I worked a really hard job, it was 10, 12 hours, I was never really able to be there except at night or on weekends to really spend quality time with the kids. But let's say, well, now I have a job where I work from home. I'm constantly there. And yes, I'm kind of my own independent contractor. As long as I meet deadlines, as long as I get things done, doesn't matter if I'm exactly 9 to 5, I just have to get things done. So if there's an emergency or the kids need some attention, and I can take an hour lunch, stuff like that. Those things I think are legitimate reasons to say to the court and to petition the court, look, this is why I think that it's a logical thing for me to have more time with the kids now.
Right, and that the law allows that, and the courts are considerate of that. They recognize that a custody order is fluid.
Sure.
It can be changed,
Mm-hmm.
and the laws allow that. And the cases that are out there support the fact that if a stipulated order was first entered by the parties, the burden to prove a change of circumstance isn't that high.
Right.
You need to show something. Something must have changed to come back and adjust custody, but they look at mostly what is in the child's best interest. Now that's where parents often fight. They always think that what they want is in the child's best interest. So that's why I feel I'm more of an advocate for the child than
Sure.
just a particular parent. I mean, I represent women, I represent dads.
Sure.
I always try to focus on what is in the child's best interest, and that may be telling my clients
Because the court is going to look for what
That's-
is in the child's best
that's
interest.
all they care about.
Right.
And now from what I understand from most expert witnesses, the custody evaluators or the judges, a 50-50 split or a 40-60 split, it's all the same to them. It doesn't really matter
Okay.
as long as it is creating peace for the parties and is best for the child.
Stability for the children.
Whatever's best for them, and 60-40, 50-50 may not be a big difference to a court or an evaluator. It is to the parties.
Sure.
Because it comes down to more control issues, and they think, oh, if I have you one extra day, I have control. And that's where we need to eliminate problems, is say, that's what we're fighting over, is
Right.
it's come up with a parenting plan that works and a parenting schedule and not focus on titles.
Right.
Because people want, oh, I have to have this title for some
Right.
psychological reason when kids don't know what title means.
Right.
They just want to see both parents
Right.
and have both parents not fight.
Right.
Now, if having a 60-40 split or 70-30 split will create peace and make the kids feel that peace, then do that.
Mhm.
It doesn't matter which parent has it. Because that's what I'm always pushing, is let's create peace.
Right.
Let's do what's best to avoid fighting.
Well, one of the things that I thought that I'd like to see changed, and I don't even know if it's possible, but I'm not trying to criticize the current laws that are in place, but I think obviously you've got to establish, for example, child support. You've got to establish who's going to pay what and why. And if the child is with one parent more, then they're obviously going to have more care, they're going to have more need, and so, if the other person makes more money, those are the things that I think, I mean, it's about as fair as it can be, but when you don't have that presumption of 50-50, then it's almost like it creates that contention because you've got to fight over, who has the kids 10 more days, and so now they're the custodial versus, well, hey, we just want things to be fair, but that's what I think creates the most contention in divorce is you're not just fighting over seeing your kid now you're fighting over kind of a survival thing. That much money a month really hurts your paycheck, or you really need it to survive. And so I think that's the main cause of contention is that whole, I just think things would be a lot better off if there was a joint presumption, and then, I wouldn't mind paying more money if I make more money, obviously, if I still felt like I had some equal time with the kids, or here's the guide that we can follow if we don't get along, but we're free to do what we want and change schedules as long as we can get along. And most people, going through a divorce at the onset when they're so mad at each other, they don't realize they still have that flexibility. So
well, yeah, I mean, there's a lot you said in there. I was trying to remember everything to comment on.
Sorry about that.
But on the end, I mean, like the best divorce decree you have is one you throw in your filing cabinet and never look at.
Right.
Because you're not fighting over that. You're not concerned about extra every single day so that I can reduce my child support or not. But that is the reality. Yeah. Money is important. Mm-hmm. This is what you need to know. Is no one can afford to get divorced. Yeah. Nobody can afford to pay child support unless you're making tons of money. Yeah. You have cases where we come up with a schedule that works and everything, and then when you plug the numbers in, you realize I can't afford that. Yeah. I just can't afford making $14 an hour to pay $700 a month in child support when I net $800 every 2 weeks. Exactly. I can't give up half my net income. A month to pay child support.
It's not you don't want to. You're just going.
I can't.
How do I How do I pay my light bill? But
then you reverse it, and the parent that's receiving the support, we'll say the mother in this case, she's like, I can't live on $200 a month in support because she works part time because my rent's $1,000 and I can work part time because the kid's 4 and I can't afford babysitting. No one can afford to get divorced,
and people don't plan for it. They don't sit down and go, hey, you're the love of my life, you're my soulmate, I better stuck, $200,000 in an account just in case we get divorced. People don't plan.
No, because she get half of it,
right?
And so
true.
That's the challenge. It's when I go to a mediation with my clients, I tell them this is your life, this is your budget, this is your child. It doesn't affect my life. What you choose to do. I'm here to guide you to make sure you understand the decisions you're making, so that if there's a challenge as to a parenting plan and things that work and things that don't work or schedules, am I helping to work through those things? Because most everyone, we try to have their case settled in a mediation session or some type of settlement, because we're not talking about millions of dollars. We're not talking about rocket science or some huge thing. We're talking about children and stuff. We can work this out. I remember I read an article from a judge in Canada, in Montreal, I think it was. I don't remember exactly in Canada, but the parties spent 3 years litigating over a schedule, and finally the judge ordered something, and awarded one of the parents custody. And dad spent $300,000, and mom spent $200,000, and the judge says, really? You spent $500,000 fighting over something that you guys can do on your own?